State of Kansas v. Daniel Barlett. And we will not take a break in between the two cases. So if anybody in the audience feels a need to leave, please exit quietly. And we hope you do come back.
May it please the Court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Mr. Daniel Barlett. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. I'll start with the first issue raised in Mr. Barlett's petition for review, whether the district court erred by refusing to instruct the jury on a requested self-defense instruction. The Court of Appeals affirmed the district court, holding that it would have been legally inappropriate to instruct on self-defense because Mr. Barlett was charged with felony murder. That holding of the Court of Appeals was based upon a holding of this court in State v. Bell. In Bell, this court held that a statute, which is now cited as KSA 215226, does preclude instruction on self-defense when a defendant is charged with felony murder. So that statute, KSA 215226, says the justification described in Kansas's self-defense statutes is not available to a person who is attempting to committing, or escaping from the commission of a forcible felony. I'd like to start out argument by setting forth what I believe the legislature had in mind when they enacted this statutory provision. I believe that the basic situation would be that if somebody, for example, were to commit a burglary, and in the course of a burglary, the homeowner became notified of the burglar's presence and persuaded them to leave his or her house by means of force. Usually, in a situation like that, if somebody is threatening you and using force against you, you have the right to self-defense. That's a statutory right in Kansas. But what KSA 215226 says is that because you are in the middle of committing a felony, you don't have that right. So if you try to use violence or force on the homeowner to defend yourself, that you will be held criminally responsible for doing that. So that basic principle that you do not have the right to self-defense while committing a felony, I do not believe supports the holding in Bell that it is always inappropriate to instruct on self-defense in a felony murder case.
If Bell was incorrect in determining what the legislative intent was, the legislatures had 15 years to correct that, and they have not done so. What do we make of that?
From that inaction, I don't think that there's much to be drawn, Your Honor. There was a Kirkpatrick case that dealt with this same issue. I'm not sure that this has been an issue that has been recurring over and over again in the Kansas Supreme Court, although it is an important issue. And I believe that at a certain point, this court has to be driven by more basic rules of statutory construction, plain language interpretation of statute, and avoiding an absurd result. And I think if you look at a plain language interpretation of statute, what KSA 215214 says is it's not available to someone who is committing a felony or escaping from a felony or attempting a felony. The problem with Bell is it doesn't contemplate that sometimes people are going to want to argue, criminal defendants are going to want to argue, that I did not commit a felony because I was acting in self-defense. And if somebody did not commit a felony because they were acting in self-defense, there is no felony to support a felony murder conviction. So I don't think the plain language of KSA 215226 supports the holding in Bell. I also believe that it would lead to absurd results. And those absurd results were detailed in a dissenting opinion in State versus Kirkpatrick. But basically, the absurd result is that the states, based solely on the way they choose to charge a case, can take away somebody's right to self-defense.
How does self-defense work in a case like this on an aiding and abetting theory? Are you arguing that that your client, Mr. Barlett, has the same intent as the shooter here, or can he have a different motivation for self-defense?
Well, it's possible. The answer is possibly both, Your Honor, but our argument would be focused primarily on Mr. McKeon's actions, whether Mr. McKeon was acting in self-defense. Because if Mr. McKeon is acting in self-defense, he's not guilty of a crime, and without a guilty principle, you can't be guilty as an accomplice.
That gets complicated on remand because Mr. McKeon has now pled to second-degree murder, correct?
That's correct.
So how do you argue that he was, as an aider and abetter, is acting in self-defense when he's pled to an intentional homicide?
Right. Your Honor, I think the answer to that is that Mr. McKeon has waived his right to a jury trial on the state's charges. So there was a time when he would have had the right to a jury to decide whether he was acting in self-defense. He decided it was in his best interest to cut his losses and plead guilty to a lesser charge. And that's the way the criminal justice system works. Obviously, that's what happened in this case.
But it's to a lesser charge in which he acknowledges he wasn't acting in self-defense.
Well, that wasn't his trial testimony. His trial testimony was that he believed himself to be acting in self-defense. But I don't think every case has to be tried on a case-by-case basis. If Mr. McKeon had been acquitted of felony murder and criminal discharge, Mr. Barlett couldn't come into his trial and say, this is a decided matter. My co-defendant was acquitted of these charges, so I'm obviously innocent too. That's just not the way it works. So that would be my answer, Your Honor.
If we were to agree with you that the Court of Appeals was incorrect in finding that the instruction was legally inappropriate, why wouldn't we find that it was nevertheless correct for the wrong reason because it was factually inappropriate? You have to pass muster on both counts, right?
That's correct, Your Honor. And the district court, unlike the Court of Appeals, ruled on both the legally appropriate and factually appropriate aspect of the instruction. I believe the district court was wrong in holding that it was factually inappropriate because if you look at trial evidence in the light most favorable to Mr. Barlett.
And the light most favorable is that Mr. Barlett was driving a vehicle that was in pursuit of the vehicle that contained the decedent.
I don't agree with the in pursuit in the light most favorable to Mr. Barlett. If you look at the interrogation statements made by Mr. Barlett, which were admitted into evidence, he says that he saw his friends drive by, he pulled a U-turn to get behind his friends, and that he ended up behind the car in which Mr. Ford was riding as a passenger by happenstance. So that's evidence in the light most favorable to the defense that there was no dispute. Now, that is not what the testimony of Mr. McKeon was. But again, in ruling on the factual appropriateness of a self-defense instruction, the district court was required to look at trial evidence in the light most favorable to the defense.
To your client. Does the record tell us how far they traveled once they turned around?
It would have been a relatively short distance. I know a map was admitted as evidence.
Is that in the record on appeal?
I don't recall at this time.
Okay.
What do we make of the fact that the friends went one direction, but your client pursued the car of the victim and went at the other direction when there was a fork in the road?
Two answers, Your Honor. First, according to Mr. Barlett's interrogation statement, he was not intentionally following after Mr. Ford when he took that fork in the road. So that's the first answer. The second answer is that I think a jury would not be compelled to find that Mr. Barlett was an initial aggressor or engaged in mutual conduct just because he's following a vehicle that he believes is chasing his friends. That's a lot different, in my opinion, than engaging in conduct that's egging somebody on to engage in a gunfight, basically. And again, if you look at trial evidence in the light most favorable to the defense, and there was absolutely conflicting evidence at trial, and I think it's apparent even from a cold record that all of the witnesses were bringing bias into their accounting of their events. What the jury made of that, only they know. But if you look at evidence in the light most favorable to Mr. Barlett, Mr. McKeon was returning fire on Mr. Ford after Mr. Ford began shooting him. And he testified that he did that because he felt that he was in imminent danger of death or great bodily harm. So I think that establishes evidence that would support a self-defense instruction. So what should have happened in this case is that the district court should have instructed on self-defense, should have given an initial aggressor instruction, should have given a mutual combat instruction, should have given a no duty to retreat instruction, basically instructed on the full state of the law of self-defense in Kansas, and then let the jury decide what they wanted to do. In Kansas, there is no right that is more fundamental than the right to a jury trial, and I don't believe that Mr. Barlett was fully afforded that right in this case.
Can you explain to me how, again, on a theoretical basis, now jumping ahead to your client, he has subsequently pled to voluntary manslaughter. So now how does it work when the act that gives rise to the manslaughter is done in self-defense, but you've taken responsibility for the killing? Doesn't they taking a contradictory stand to what the reality is? He stands guilty of that crime, has been sentenced for that crime, and in fact has been given credit for taking responsibility in a reduced sentence for that crime. How do we factor in that?
Well, I don't think it really factors in at all in this court's analysis, and my reason for that is basically a guilty plea is a contractual agreement between a criminal defendant and the state. And Mr. Barlett made his own decision that it was in his best interest to plead to this lesser crime to avoid the possibility of getting a life sentence.
Any case law to support that? Because that a guilty plea is a contract. I recall the case law says a guilty plea is an admission of all the elements.
Well, I suppose I should say plea agreement.
Okay.
Pursuant to a plea agreement, he pled guilty, would be the more accurate way to state that. But the basic premise remains. And I would say that he has not waived his right to a jury trial with respect to the criminal discharge. And the Court of Appeals found that to be the case. The state elected not to petition from that ruling. So I don't believe that that is an issue before
He's not
this.
waived his right, but what happens on remand if he's given a trial on that and there's evidence that he's pled to the crime, really the lead charge of the crime, and the underlying count of discharge of a weapon at an occupied vehicle is what gives rise to the homicide?
I guess the short answer...
How do you do that in self-defense but then admit that you did it in the heat of passion?
Well, and Your Honor, I don't think there's any way to view this as a voluntary manslaughter offense, to be quite candid. This court is...
Well,
but at any rate...
That's what he pled to.
That's what he pled to. The short answer is, when this case is remanded, the attorney for the state, if he wishes to try and get that into evidence, if he or she wishes to try and get that into evidence at a subsequent trial, assuming that a subsequent trial is to occur, the attorneys could dispute and argue about whether it was admissible evidence at that point in time. That would be my answer, Your Honor. And I am not going to say that I know at this time how a court would necessarily rule on that.
Do we have any further questions? Thank you, counsel.
Mr. Chief Justice, Associate Justices, Counsel, and may it please the court. Again, my name is Daniel Obermeyer. I'm Assistant District Attorney in Wyandotte County for the state of Kansas. Your Honor, since the majority of, well, basically all of Mr. Bartlett's argument revolves around the self-defense instruction, that is also what I will address. First, I think that this court needs to look at the record very strongly in this case, and I would cite volume 11, pages 1486 through 1489 specifically. Before that time, that is where Judge Russell is giving the legal basis he's making for his decision. And in this part of the record, he is addressing the factual basis. Why, factually speaking, it is not appropriate to give a self-defense instruction in this case. And quite frankly, this is what was done in State v. Bell. And in all the other cases that I believe I can find, where a forcible felony is being committed and where the defendant wants to argue self-defense. It doesn't appear to be an absolute bar, the statute 21-5226. So in terms of that being an absolute bar to a defendant claiming self-defense, I don't think that's the case.
It's not absolute, but doesn't it leave all the power in the prosecutor?
No, it does not, Your Honor.
How not?
Because the statute does not say if a defendant is charged with a forcible felony. The language of the statute, if I may be precise here, is if a person is attempting to committing or escaping from the commission of a forcible felony.
How do you know whether that is true or not?
That claim is what I would argue. And that's why jury instructions are always fact-intensive. And that's what the court, quite frankly...
What's the evidentiary, or what's the standard of proof? I mean, is it just like preliminary hearing? If you get past a preliminary hearing, then there's evidence? Is that enough?
In terms of whether the state has made a prima facie case that
Right.
they're committing or...
Correct.
Okay. I would say that when we're looking at it in the trial setting, the state's put on evidence that the defendant has committed this crime. That's enough from that point of view to show that they are in the commission of the
And
crime.
isn't homicide itself a forcible felony?
Yes, it is, Your Honor.
So how does a defendant ever get self-defense once at trial? Once the state's proved up its case enough to get to a jury?
Well, what this court has considered, and I note that Bell also considered this, and the trial court, Judge Russell, also cited State v. Gonzalez in his decision when he was analyzing the factual appropriateness. The relevant evidence must establish that the defendant honestly and sincerely believed that it was necessary to kill in self-defense, and a reasonable person would have perceived that necessity. So that's the defense burden, if you will.
That's on the facts, though, right? Are you conceding that the instruction was legally appropriate here?
I don't know if I'm conceding it's legally appropriate, Your Honor. I'm just saying I don't think that that is really before the court, since the majority, I would submit the majority of Judge Russell's decision was based on the
Well,
factual.
doesn't our sort of analytical path we take on these, doesn't it start with legal appropriateness and only get to factual appropriateness second?
Well, yes, Your Honor, that's true.
I understand you're resting, at least in part in this case, on your argument that it's not factually appropriate. I just would like to know where the state stands with regard to legal appropriateness.
Well, the statute, I just have to say that the plain language of the statute, I mean, the way that the courts have applied it, it seems to be that we take this factual.
Were we wrong in Bell and Kirkpatrick then, when we said that it was if you're charged with a forcible felony, precludes getting a self-defense instruction? Pretty much said that.
I wouldn't say that you are wrong in that, Your Honor.
So he's charged with a forcible felony.
Correct.
Would bar him from legally anyway from getting the instruction. You don't even need to get to the factual analysis.
Well, in Bell, and I believe in Kirkpatrick as well, this court addressed the factual underpinnings as well. So just from my point of view, it's hard for me to distinguish that in this analysis.
In Kirkpatrick, it was pretty cryptic, wasn't it? Just we're going to limit this case to its facts with no explanation?
Those I have no comment on that, Your Honor.
Okay.
But I think that if we look at these cases and decide them according to the facts that they're presented, that Judge Russell ultimately made the right call in saying that because of these facts, that Mr. Bartlett was not entitled to self-defense because Mr. McKeon was not entitled to self-defense. Mr. McKeon first didn't testify, and his statement to police, he didn't testify it was necessary to kill, to use deadly force. He said self-defense repeatedly, but he did not use the words to kill. And second, a reasonable person, the second prong that the court used, a reasonable person would have perceived the necessity of self-defense. A reasonable person wouldn't have done that. A reasonable person would not be the aggressor in this situation, sort of provoking.
Well, wasn't there a very serious fact question here? McKeon testified that he and Bartlett were shot at twice before any firing was done by them.
Correct.
So why isn't that just a disagreement on the facts at the best, but in the light most favorable to Mr. Bartlett? Why isn't that sufficient?
Because there has to be some corroborating evidence to support that statement, Your Honor. In, for example, State v. Mathis, considering that counsel cites in his brief, the appropriateness of a self-defense instruction in that the defendant claimed that the victim was wearing a bulletproof vest, that he was armed, and that he was unstable, essentially. And there was nothing other than the defendant's testimony to corroborate that. So, yes, you'd look at the evidence in the light most favorable to it, but by the same token, if there's nothing else, then it's not really appropriate to give that instruction.
Explain that to me. We look at the evidence in the light most favorable to the defendant, but the defendant has to show corroborating evidence.
Yes, there has to be. That was the one of the points in Mathis, Your Honor, that there was nothing really to corroborate the defendant's version of events, if you will. So the district court did not.
Well, if you're weighing credibility of the defendant's statement, how is that looking at the evidence in the light most favorable to the defendant? That's a weighing of the evidence, or is assessing credibility, which is completely different than taking the evidence in the light most favorable to one side or the other.
I guess I would distinguish that. Your Honor, by saying that, you know, the light most favorable to the defendant, it can't just be their own testimony. There has to be something independent of that to corroborate that. And if that's lacking, then even the defendant's, if there's nothing to support the defendant's story, then it's hard for the court, in exercising its gatekeeping function, to give on what instructions to give. Should take that into account.
So if a case is just a pure credibility determination, the defendant never gets a self-defense instruction? If it's just he said, or he said, she said?
Well, in that hypothetical, Your Honor, I would say that if it's just testimony on both sides, then the defendant would probably be entitled to a self-defense instruction. If there's nothing to corroborate state's witnesses, nothing to corroborate the defense side.
Well, was there any evidence put on by the state here that would have tended to disprove the testimony of the firing, the shots being fired?
The testimony, I'm trying to remember if it was the statement or the testimony of Mr. McKeon, that they recovered the revolver that was held by Chad Ford, and they disposed of the bullets. It's not known where they were disposed. They didn't tell police where, so those were not recovered. So allegedly, those the two shells, the two fired shell casings that would have corroborated their story were not present for the jury or the court to consider. So in that circumstance, no, there was nothing really to corroborate their story. And the undisputed evidence was that Mr. Bartlett made a U-turn, came back around, sped up, kept track with the blazer containing the victim, and then through his assistance, Mr. McKeon was able to get shots off, one of which hit and killed Mr. Chad Ford.
Even if you can't corroborate the firing of the shots by the victim, it does seem that there is evidence corroborating that he had a gun held outside the car. There's DNA on the gun, and the gun drops to the pavement, and the victim falls back into the car. So it seems like at a minimum, at light most favorable to the defendant, there was a gun pointed at them, which could have, why wasn't that enough for self-defense instruction?
Because of the circumstance leading up to that, the defendant is driving towards them, putting themselves in this dangerous situation. The testimony, there was testimony that the defendant knew that these people were armed. So he's putting himself in this dangerous position. And I would note that under 215226B, basically you can't provoke someone into doing violence on you so that you in turn can kill them.
Right. Provocation and failure to avoid are two different things, of course. Why isn't this just a jury question? I mean, what would be so wrong if we flipped Kirkpatrick and Bell and said this is a jury question?
Well, first, I think that it would run contrary to the intent of the legislature, which wants some safeguard on defendants who commit forcible felonies not being able to claim self-defense under appropriate circumstances. So I think that for that reason, it would be appropriate not to overturn Bell and Kirkpatrick. And second, I think that the analysis we currently have, which is mainly looking at the facts surrounding a case and then determining from that whether or not it's appropriate, and of course doing as the court did in this case, construing them in the light most favorable to the defendant, whether or not it's appropriate to give an instruction, I think that those are fairly good safeguards already.
Do we have pieces that don't fit here because Bell and Kirkpatrick were decided before the framework that we're now talking about of moving from legal appropriateness to factual appropriateness? At that point, that stair step was not clearly delineated in the case law. Do you think that's the problem we're having?
Potentially it could be, Your Honor, because if you look back, if you just reread the Bell case, it certainly does address the facts surrounding whether or not it's appropriate. And I think that, you know, that has evolved over time to what we have, the status quo we have right now, where the court knew its duty, it was to consider whether or not it was factually appropriate, and it did that.
Counsel, help me, walk through this very simply. Under 215226, what forcible felony are we talking about in this case?
It would be criminal discharge of a firearm.
And can that charge peacefully coexist with a claim of self-defense?
I'm sorry, Your Honor, I'm not quite sure I understand that.
Well, if you have a situation where two people are shooting at each other, it sounds to me like the state can charge one of them with a forcible felony, and when that defendant says, but I was defending myself, the state points to the statute and says, you can't do that when it's a forcible felony and you're shooting at this other individual. So why have the defense of self-defense in a case involving a forcible felony? If you could explain that.
Well, I think that in a case where the defendant is charged with criminal discharge, and you have this scenario, then the court has to look at the facts and determine whether or not it's appropriate to give a self-defense instruction. That would, and as far as the legislature is concerned, I can't really say I have a good answer for that, except to say that the language of the statute doesn't preclude someone from asserting self-defense because they
why not? Why wouldn't it? If you're saying that the act of defending yourself in a deadly force scenario would always be a forcible felony, potentially, if self-defense wasn't justified, right?
Yes.
So anytime you have a claim of self-defense, you also have a forcible felony, and if you're going to interpret 5226 C1 or C, or A, I mean, is attempting to commit, committing, or escaping from, as meaning the act of self-defense itself is potentially a forcible felony, then self-defense doesn't exist in the deadly force scenario. Is what I understand the chief is asking.
In that hypothetical, I can see that as being possible, yes. However, I think...
Well, no, really, if you interpret subsection A is attempting to commit, committing, or escaping from the commission of a forcible felony, being discharging the weapon at the occupied car, that was the claimed act of self-defense, then bright line rule, there is no self-defense. And I'm asking, how can there ever be self-defense in a deadly force case when the response is always going to be a forcible felony if it's not self-defense? Do you understand what I'm asking you?
I do.
The bright line rule is self-defense doesn't exist in the deadly force if we interpret it the way you're asking us to.
Well, Justice Johnson, with all due respect, I don't think I'm interpreting you to interpret 215226A as being if someone is charged with a forcible felony, that means self-defense is precluded to them. I'm sorry, I thought I don't want to, I don't think that that's provided for.
You don't think Bell and Kirkpatrick said that?
Well, they said it only in the most literal sense of it. The actual analysis of Bell, for sure,
They
looked
said
at
it, but they really didn't mean it.
it looked at. I
understand. I'm not going to hold you to the language of those, but you understand what our dilemma is here.
I understand, Your Honor, but I just want to assert that what I think is being done in precedent, and what I think was done here, is a thorough factual analysis to determine appropriateness. I see that I am out of time. Unless there are any more questions, I would ask to briefly sum up.
Do we have any more questions of counsel? Since we've taken a lot of your time with our questions, we'll give you 60 seconds to sum up.
Thank you, Your Honor. Much appreciated. Essentially, we're asking the court to affirm the Court of Appeals on all of the issues that are now before the court. Simply put, with the jury instructions, the district court followed the law to the letter in each of the jury instructions. For self-defense, following the case law there and giving a factual analysis to support that. For the mere association instruction, also following the case law and the literal words of the PIC. I would note there that the main defense in Barlett's closing was self-defense, with mere association sort of being tangentially woven into there. So not only was he not precluded from making a self-defense defense, but also a mere association defense. On the whether or not intentionally must be instructed for the aiding and abetting, I would refer this court to the Court of Appeals again, State v. Betancourt, saying that it's a principle of criminal liability. It is not itself an element requiring instruction. And finally, the court did not abuse its discretion when the state faced technological issues in playing State's Exhibit to Mr. Barlett's confession. We'd ask you to affirm the District Court and the Court of Appeals. Thank you, Your Honors.
Thank you, counsel. You're reserved 3 minutes for rebuttal.
With rebuttal, I guess I'd just like to comment on how I read Bell and Kirkpatrick. As I interpret Bell, what it literally says is that if you are charged with a forcible felony, you are not entitled to a self-defense instruction. I don't think that literal holding has ever been followed by Kansas appellate courts, because if it were, you would never instruct on self-defense ever. Basically, every act of self-defense in a felony case could be described as a forcible felony if self-defense were not invoked. So what I think Bell was holding which I also believe is wrong, is that it is never appropriate to instruct on self-defense in a felony murder case. And I think the Bell Court, the error of the Bell Court was basically that its reasoning was circular. It was saying that because there is a felony inherent in a felony murder charge, that self-defense cannot be a defense to felony murder. I think that's what the Bell Court was trying to get at. And I think the problem with that legal analysis is that a self-defense claim to the underlying felony would take away the commission of a felony, the element, an element of felony murder. And I know that that is very convoluted to explain, which is probably...
But what you're saying is that you can have, because felony murder is defined as during the commission or before, during, or after the commission of a felony. And if you're doing that, then you fit right into the language of the statute. But what you're saying is you can still impose or ask for self-defense for the underlying felony, not for the death. Is that what you're saying?
That's exactly what I'm saying, Your Honor. And to be clear, when you give a self-defense instruction on a felony murder case, it should cut only to the felony element of the felony murder charge. You're saying, because I acted in self-defense, I did not commit a felony. And
That would
because I did
only-
not commit a felony, I'm not guilty of felony murder.
And that would be applicable only when the underlying felony is the kind of felony that is subject to a self-defense defense. I mean, you can't plead self-defense to a burglary charge.
Exactly,
Right.
Your Honor.
And that would potentially at least resolve both the statutory language and the spirit, if you will, of Bell. Is that what I'm hearing you say?
That's exactly right, Your Honor. This type of issue would not come up typically in a burglary felony murder case or a drug transaction felony murder case. Unless this court has any further questions, I am prepared to conclude my argument at this time.
Any more questions? Thank you, counsel. We thank both of you for your arguments this evening. Court will take this matter under advisement.